Hello everyone, this is the video of Legal Studies, Class 12, Unit 3, namely Arbitration, Tribunal, Adjudication and Alternative Dispute Resolution. From last a few videos, I have been discussing this unit. But in those three videos, I have discussed about the adversarial system and inquisitorial system, which are part of basically litigation. So from today I will start ADR, that is Alternative Dispute Resolution. So the first thing that I believe definitely comes in your mind, that is what is Alternative Dispute Resolution? So let's understand first about this term. Alternative Dispute Resolution, or simply ADR, refers to a set of practices and techniques focusing on the resolution of legal dispute outside the courts. So pay attention. What is important in this sentence is it is a set of practices and techniques to resolve the dispute outside the court. Okay? So it is a technique that resolves the dispute but outside the court. Okay? It is non-adversarial and flexible techniques of adjudication of legal disputes. I believe now you must aware with the term adversarial, as we have discussed in detail, So it is non-adversarial, as adversarial is judicial methods, okay, that is the method of litigation, especially in India, So it is non-adversarial and flexible techniques of adjudication of legal dispute, which largely involves different methods including arbitration, mediation, conciliation, lok adalat, etc. Okay, so all these are the types of ADR, that is Alternative Dispute Resolution. Okay, so I believe you must understood what all about the ADR is. So now let's check out a little its historical background. The history of ADR is centuries old. During the Vedic age, India had well-established specialized tribunals such as Kula, that is for disputes of family, community, tribe, castes, races, etc. Secondly, Shreni, that was for internal disputes in business, corporation, of artisans, and Puga, which was for association of traders, commerce branches. Okay, so these were the methods, specialized tribunals to resolve the disputes. For the family, it is known as Kula. For the business or corporation, it was known as Shreni, and for association of traders, commerce, it was known as Puga. Okay. In these institutions, interest-based negotiations were prevalent, under which a neutral third party intended to identify the underlying needs and concerns of the parties in dispute. So see how beautifully the dispute resolution methods were practiced at that time. In addition to this, even in modern India, people's courts, that is Lok Adalat or Panchayat, are pretty popular, especially in village area of India. Along with this, the modern means of ADR also developed, such as arbitration, mediation and conciliation. Okay? But don't worry, I will discuss all these terms in detail. Likewise, wide range of methods and processes are developed under the heading of Alternative Dispute Resolution. Okay, now you have the brief background about the ADR. So let's start with its meaning. So what does it mean? Alternative to the adjudication through the court proceedings or litigation are referred as alternative dispute resolution technique. So it is alternative of what? That is alternative of litigation. Under this method, normally a third party, referred to as neutral, assists the parties in the disputes to make a commonly agreed decision through acceptable agreement. Okay, so what is happening here? See, in this system, a third party who's supposed to be neutral, and he plays a role through which what he does, he assists the parties who are in disputes and help them to make a commonly agreed decision. Okay. Secondly, the referee, you can call him referee, the person who is neutral and trying to help out these parties who are in dispute, sometimes also facilitates the parties in conflict to arrive a common solution. Okay, so what it does, in the first sentence it is saying that referee helps or assists to make a decision. Secondly, the referee also facilitates the parties to arrive on a common solution. So it is a sort of win-win situation. Interestingly, such methods preserve the personal and professional relationship by resolving the dispute in friendly manner, which normally not possible through litigation, and encourage to maintain the healthy relationship between the parties. See how beautiful it is. It is not only resolving the dispute, but at the same time it also preserves and maintains the healthy relationship between the parties. Okay, so I believe now you must understood the meaning and concept of ADR. So let's discuss its benefits. Okay, following are the significant benefits of ADR. ADR is flexible mode of dispute resolution. As flexible in what sense? As parties have the choice to choose place, date, time and arbitrator or mediator. So here parties have the freedom to choose the things, to decide the things. Okay. Secondly, ADR is less formal technique of dispute resolution in comparison to litigation, that is complete formal. It is less formal. Okay. Thirdly, it is faster mode of dispute resolution, and you know that how slow litigation is. Okay. Next one is, it is comparatively cheaper way to find out the solution, and litigation is of course expensive. Okay. Lastly, ADR encourages many other disputants to quit the litigation and choose ADR as it reduces delays. So these are the major advantages or benefits of ADR. Okay. Now let's discuss what are the reasons of growth of ADR in India. That is basically in modern India. Though while discussing the historical background, we have seen that ADR is centuries old concept and methods of dispute resolution in India. But in the present context, in modern India, what were the reasons? Okay, because of which ADR grew. Okay, so let's check out. Following are some of the important reasons. The first one is the ratio of courts, judges and number of cases are very wide, and it creates an inadequacy and unpredictability within the justice delivery system. You know that how many cases are pending inside the court. Okay, so because of that, people are started migrating towards ADR. Okay, this is the first reason. Second one, the complex and lengthy laws and arduous legal procedures along with absolute continuation of some pre-existing legal statutes discourage people to choose litigation. Okay, what does it mean? That this sentence simply saying that we have very complex and lengthy laws, and the legal procedures are so painful, are so, you can say again, complicated, because it needs certain kind of procedure, because you need to follow certain kind of procedure, which is of course sometimes painful. Okay, and not only this, there are certain systems which are so old, even then we are practicing that, we are pursuing that. So collectively these things discourage people to choose litigation these days. Next one is the increasing cost of litigation and prosecuting or defending a case. are another demotivating point. The court fees, lawyers' fees, and incidental expenses, everything is increasing like anything. So, regarding the cost of litigation, we know that how much expensive it is. Whereas ADR, in comparison to litigation, is frugal, very economic. Okay. Lastly, delay in disposal of cases increasing the pendency in all the courts, because the number of cases pending in the court every day growing, okay, which is one of the biggest causes of distraction for the parties in disputes. So these four are the major reasons of growth of ADR in India. So this is all about the ADR, that is alternative dispute resolution. In my next video, I will discuss about the types of ADR. Okay, so keep watching.